You've reached the stars, now let's see you conquer galaxies. You've gone for gold, let's show you 2 more treasure chests.
Your story doesn't have to end with you. As a matter of fact, it can continue into the next generation.
The only way to move is up, the way to go.
And the generation after that.
Don't stop.
After all, you've worked hard to get to where you are. Why should your wealth end with you? Let your story continue.
Meristem, let's grow wealth for you.
All right, good evening, everyone. Can you hear me?
Yes, we can.
All right, thank you very much. Good evening and welcome again to Meristem Trustees webinar titled Preserving Your Legacy Through Estate Planning. And as you know, Meristem Securities Limited is the group company under which Meristem Trustees functions. And the job of Meristem Trustees is to ensure that your assets are managed properly, especially through estate planning, so that you can easily pass your assets on to your loved ones when you are gone. Our hosts for today's webinar are Felicia King and Ibidolapo Olufade. Felicia King is the head of legal services at Meristem Trustees Limited, while Ibidolapo Olufade is the head of private trust services. I'll welcome both of them. Felicia and Ibidolapo, you have the floor. Thank you.
Good evening, ladies and gentlemen. My name is Ibidolapo Olufade, and I'm very, very elated to be a part of this webinar today. And I'm very, very sure that all the attendees would learn valuable lessons about their estate plan at the end of the session. Thank you very much.
So let's go right into it. What is estate planning? I'm sure over the last year or so during the pandemic, we have all been inundated with a lot of webinars and information about estate planning. And we have found the need to re-educate people and to re-emphasize estate planning, especially during these uncertain times, during this pandemic period, where we've seen that there are no shorties in life. No one expected 2019, 2020, and even 2021 to go as it's going. But the best we can do as humans is to plan for tomorrow. Not just tomorrow, but to plan for down the line. So, what is estate planning? Let me take it from the beginning. What is an estate? An estate basically means anything you own. As much as you own something, you can plan against it. On a typical day, an average Nigerian will plan out what they intend to do for the day. Wake up at 6 a.m., get to the office, get the work done, head back home, have lunch, have dinner. No, basically, humans, we are built to plan our lives. So now the question is, why do you want to stop planning after you leave the earth? It's a short thing that none of us are living here alive. So now it begs the question, what do you want to do after you're left? How do you want to pass the legacy? How do you want to transfer all the things you have worked for to the next set of people, your beneficiaries? Now, that is what estate planning is. The law recognizes this, and that is why we have made provision for various ways in which individuals can plan their estate. Now, the typical ways or the most popular ways the law has made this provision, mediums that the law have made for people to plan their estate, either through wills, creation of trusts, powers of attorney, or gifts. These are the most popular ways to plan your estate. Now let's take it down again. Which one fits who? Now, as professionals, we at Meristem Trustees have the expertise to advise you. Our advice will be based on your circumstance, your family structure, your asset owned. All these play a big role in how you plan your estate and the tool you use in planning that estate. When you are looking at estate planning, you have to make sure that You are not looking at it in the vacuum. We have expertise at Meristem Trustees to give you the advice based on your current circumstance. Because we know what works for Mr. A might not work for Mr. B, because their circumstances and their assets and their families are different. So based on that, we'll be going deep into the typical ways, the most popular ways we have found in our experience and in industry-wide experience that works for people. Now, the industry puts, this industry, trust industry, allows different ways as permitted by the law, as said earlier. But we are going to drill down today on wills and trusts. Now, these are two major ways that you can plan use to plan, two major methods you can use to plan your estate. Based on that, sorry, please hold on. I just want to confirm that I'm being heard again. Okay, based on that, we are going to drill down on how, why, and what wills and trusts are. I believe at the end of this session, you will have more knowledge and you avail us of the opportunity to use our expertise to advise you better based on your circumstance and your situation and your assets. Thank you very much once again for this opportunity. Please go ahead and listen as my colleague, Mr. Lapo. Please go ahead and listen as my colleague, Mr. Lapo, takes you through wills and trusts. Thank you.
All right, thank you very much, Felicia, for that insightful presentation. We would move now to Ibidolapo. Thank you. Dolapo, can you hear me?
Yes, I can hear you. Can you hear me?
Yes, you have the floor. Thank you.
Okay, permit me a few seconds to share my screen.
Okay.
All right, can you see my screen?
Yes, it is
Thank you
clear.
very much. All right, thank you very much. And thank you, Felicia, for that insightful introduction. Once again, my name is Ibidolapo Olufade, and I'll be speaking through preserving your legacy through estate plan. And just like Felicia mentioned, there are different estate plan options that individuals have, which could be will or trust or power of attorney or deed of gift or joint ownership. But for the sake of today's webinar, we'll be drilling down on wills and trust.
You've reached the start.
Now, when you think about life and the different thoughts that people have about life in general, you would find that one or all of these sentiments are present. We've had people say, oh, I have a small family, so why should I plan my estate? My children will not fight over my assets. They are lovely kids, they love each other. People tell themselves they are still very much around. Some would even tell you that when they pass on, their assets will automatically go to their spouse. And one of the things we learned through 2020, as alluded to by Felicia, is the fact that uncertainty stared us in the face of the pandemic. And then we are now so aware of that cliche, people talking about uncertainty, people talking about all of this. But more importantly, what 2020 also showed each and every one of us is why we should plan our legacy. Some few days ago, after the Father's Day celebration, some questions were asked, specifically about whether midlife crisis is a thing. And people said that, yes, for some, midlife crisis is a thing because it's at that point where people begin to think about life in general, people begin to think about their legacy, people begin to think about what people here would say about them once they pass to the great beyond. And then when you look at the Maslow's hierarchy of needs, basically, it talks about our physiological needs. It talks about other needs. When you go through that pyramid, your physiological need, basic needs to survive and all of that. And then when you look at it side by side with how we live our life, we find out that at a point in our lives, all we care about is our essential spend. food, clothing, shelter. And then it gets to a point, we begin to think about discretionary spend. How much money do I have left to maybe vacation, send my kids to elite schools and all of that. And then it gets to a point in our life when we then begin to think about our legacy. We begin to think of what we are going to leave to our beneficiaries. We begin to think about how our assets will be managed. Because beyond the fact that we even provide for our beneficiaries after we are gone, a lot of people have very beautiful legacy that needs to be protected. We are all too familiar with sprawling big houses in the villages that nobody occupies. We're all too familiar with that great artist who has catalog of great music, but no one is commercializing once they are gone. We're all too familiar with that person who had a fantastic educational center, but nobody is managing once they are gone. So when we are talking about the preservation of a legacy, it even goes beyond the fact that, oh, I need to provide for my beneficiaries. I need to ensure that their lifestyle is maintained. It's also about you've lived a great life on earth. Now that you are gone, how far with that life? And that is why I love to quote the prolific author of J.K. Rowling when I'm talking about estate planning. And J.K. Rowling said something very instructive. She said, to the well-organized mind, death is but the next great adventure. That is, once you've organized your affairs here on earth, to die is an adventure. You look forward to death. You look forward to the fact that you'll be absent, you understand, knowing fully well that your affairs are in great and capable hands. And so what we'll be doing here today is to expose to you the tools that you can use to organize your life such that you can have a great adventure in the great beyond. So basically, we talk about estate planning, and Folusho has done a great job in trying to explain what estate planning is. But again, when you look at estate planning, I'll quickly just mention one or two things about it. It's a combination of two words. We're all familiar with what plan is or what planning is, but a lot of us are not familiar with what estate means. When people hear estate, they think about a gated community somewhere. But really, an estate is the totality of the property that anyone owns. Your real property, which could be your land, your machinery upon your land, your buildings, and all of that, and includes also personal properties. Personal properties would be your cars, your jewelries. I mean, all of those fanciful things that you have, all of this make up an individual's estate. And so when you then put plan by side of estate, simply means how you plan your properties. And then if we are to go deep into it, estate planning is simply a process where a person arranges their life, a person arranges their assets in a way such that there is an effective transfer of those assets, whether when they are alive or after they are gone. An important thing also about estate planning is that it is an opportunity for you to be able to dictate your affairs without the say-so of third parties like the court or administrators that you do not want to meddle in the affairs of your estate. Now, going to the meat of today's discussion, what are the tools that you can use for your estate plan? And like I said, I'll be drilling down on wills and trust. So we are all familiar with wills, whether by watching Nollywood or hearing stories of an uncle or distant relative whose will was challenged and all of that. But again, as popular as will is, there are a lot of misconceptions about will. So first things first, what is a will? As you can see on my slide, a will is a document in which a person directs how their property is to be distributed upon their demise. But a will does more than that. So in a will, you can appoint you can appoint your executors, you can appoint guardians for your children. As well, you can appoint a trustee through your will. So a will is simply, so for me, I would also broadly say that a will is a document that contains instructions about how you want your affairs to be managed after you are gone. And when you're talking about a will, it's important for us to understand some key terms. So you have the first person, a testator or a testatrix, depending on the agenda, but we'll just use the general neutral term today, testator, to mean anyone who writes a will. Then the second important person when writing a will is the executor, because like I always say, when you have a will, it's more or less having a ship you need a captain of that ship, or you need a sailor. So basically an executor is a person who drives your estate after you are gone, who ensures that everything is done. And when you look at it, appointing an executor is probably the most important thing you will do while having estate. As a matter of fact, probably more important than even writing all of your assets in your will. And then you have beneficiaries, those who you have stated that they will take one or two things under your will. And so, like I said, there are a lot of misconceptions about will, even though it's quite popular. We all see it in the movies. And the first misconception here is that after you are dead, your will be read in your sitting room. At least we've seen that in the movies a lot of time. But as we go on, you will learn that you do not read your wills in your sitting room. There's a process called the probate process, where your will is proved, where you go to the probate registry to have your will unsealed and read by the registrar. We need to understand that. We also need to understand some formal requirements of a will, and that's the fact that generally a will needs to be in writing, and it should also be written by someone who is of age, that is 18 years and above, and also the fact that you need to have those who are called witnesses to your will. And so one of the things we do at Meristem Trustees is to guide our clients through all of this intricate process of writing a will, because it is more than just putting pen to paper. There are formal requirements that guide having a will. So just like I've mentioned, a will is a veritable means of planning your estate, and it is probably the most popular of all your estate planning tools, where you have that freedom, what is called the testamentary freedom, to plan your estate, to state that, okay, these are the assets that I have, this is who gets what, this is when they get it, and this is how it should be given out. So you have that freedom to state all of this in your will. But then there are challenges with writing a will, or more or less, I should say, probably some little demerits that people see in a will. And then we then have what is called a trust. Now, the idea of a trust came about as a doctrine of equity, whereby you have a person, in this case, say person A, called the settlor, who then transfers his asset to another person, say person B, and in this case, we'll call that person the trustee. And that trustee has the mandate to hold that property for the benefit of individuals called the beneficiaries. So in short, a trust arrangement looks at three parties to that trust. You have the settlor, you have the trustee, and you have the beneficiaries. And then the settlor sets a trust, or the settlor transfers their asset to a trustee, an entity like Meristem Trustees Limited. And Meristem Trustees Limited is to hold and manage those assets for the benefit of named individuals who are called the beneficiaries. The interesting thing is that the settlor, the person who sets up the trust, can also be the beneficiary. And so when you look at some of the challenges that people have with writing a will, in my next slide, I would mention some of those challenges. So people have now found a way through the trust process of dealing with these challenges. So when people weigh their options, they look at what these are the demerits of writing a will, and then they think that the demerit outweighs the merit, then they can use the trust option. Now, we have different types of trust. You have what is called your living trust. Why is it called the living trust? It's from the word living or life. This is a trust that kickstarts while you are alive. So while you are alive, you see how the trust is managed. You see how your instructions are being carried out. You are able to monitor the activities of the trustee. So it is called the living trust. And then you have what is called the testamentary trust. Now, so we have two words here, testament and trust. Recall that I mentioned that a will is what is called a testamentary document. I also mentioned that having a will gives you a whole lot of powers, and one of the powers is creating a trust under that will. So when you create a trust under your will, you have what is called a testamentary trust. So oftentimes, a testator to a will may have infant children, and because they have not come of age, they may not be able to manage the assets left for them, or the testator has businesses, and the beneficiaries do not have the requisite skill and expertise to manage those businesses. So in his will, he can then direct that some of these assets be managed by a third party. So in that case, a trust has been created. So the trust can be created whether impliedly or expressly. And so you have what is called the testamentary trust. And so there are other trust arrangements that you have. You can have a trust arrangement that is solely for the education of your children, which is called an education trust. And then you can also have a nominated fund where you have fund with a certain organization, and then you state or you nominate that the fund be paid to a certain person or group of persons after your demise. So these are broadly the estate planning tools that you have. And like Felicia mentioned, you also have other options: your power of attorney, your deed of gift, having joint ownership to properties. But like I said, we've drilled down to wills and trust today. So what are the merits and demerits of these options? So for example, one important pro of having a will is the fact that you have that option, that freedom to leave your estate to whoever you choose to leave it to. So that is what is called testamentary freedom. So you can choose to give your estate to anyone who is not even a member of your family. So you have that freedom. So you can name a guardian or administrator for your children and provide for them. So that is one other immense advantage that having a will has. And like I mentioned in the previous slide, you can create a testamentary trust. You can choose your executor, and you can amend or revoke the will as long as you are alive. So, but then the will option also has some number of disadvantages. So one is the fact that there is a possible challenge to your will. So the fact that you have a will, the fact that that will is watertight, does not prevent anyone from coming to challenge it. Whether they will win that challenge is a different thing entirely. But having a will oftentimes exposes that will to the possibility of a challenge or a suit, a probate action. Another thing is restriction to testamentary freedom. And it's important to mention this. Although we stated that when writing a will confers freedom on you, you can leave your estate to whoever you choose and all of that. But there is an exception. And so it's important that you understand where you are from, your place of origin. So depending on where you are from, there may be a restriction to your testamentary freedom. So for example, in Lagos, the wills law of Lagos State does not have a restriction to your testamentary freedom. So that means that whether you're a Muslim, Christian, you are whatever, you can give your asset to whoever you want to give it to. But there are states in Nigeria, like Oyo State, like Kwara State, like most states in the northern region, that have restrictions to testamentary freedom. And these restrictions can come in two forms: one, customary restrictions, and then Islamic restriction. So probably the most popular customary restriction to testamentary freedom is the Benin custom, whereby the testator would have to leave his house that he lived and died in to his surviving son, his eldest surviving son. So that is one major restriction to testamentary freedom. And this has been litigated up to the Supreme Court, and the court has affirmed that yes, this restriction is in place. And also the restriction to testamentary freedom on the ground of religion, especially Islamic law, is the fact that you cannot give out more than 1/3 of your assets through the English means of will writing, that is to third parties. So the other 2/3 must be in accordance with Sharia rules or Islamic laws. Then your will also has to go through the probate process. And then one particular headache here is the fact that you have to pay an estate tax of 10%. And also it's a public record. It becomes public at the point that the will is proved and probate is granted. That is when that will has been unsealed by the probate registrar. It then means that interested members of the public can apply to see what is in that will. And then it may not fully address some of your concerns, especially if there are restrictions to your testamentary freedom. And then there's also the possibility of the demise of your executor. And that is why one of the things we also do at Meristem is to provide executor services, because generally speaking, a corporate lives on. So if you appoint a corporate like Meristem Trustees Limited as your executor, you are not going to die. We are here to execute your estate. So, but for people who appoint individuals as the executor, and those individuals do not have a will of their own, after their demise or some sort of incapacitation, it may then fall to the court to appoint an administrator over that will. And so looking at all of these, some of the cons of having a will, so like I said, trust has now come to remedy some of this. So one important thing here is that when you have a trust, there is no need to go through probate. It avoids the probate process. Having a trust is a document, a private document between the settlor and the trustee. And then it does not require the input of any third party at all. As a matter of fact, you can even have a trust that is oral in nature, but because of documentation, you always have a trust deed, because what is required of you are what is called the three certainties. Certainty of intention. Do you intend to have a trust? Certainty of subject matter, that is the assets you want to bring under trust. Are you certain of them? And then certainty of objects of the trust, that is your beneficiaries. So once all of these certainties are present and you're able to prove the certainties, it doesn't even matter if it's reduced into writing. Unlike a will, that it has to be in writing for it to be formally recognized by the registry. And then you also have the option to manage your affairs during your lifetime. If you have a will, it means that the will only come into effect after your demise. But for a trust, it's not like that. So I mentioned that you can have what is called a living trust, whereby while you are alive, you are able to manage your affairs. You monitor the activities of the trustee, and you are sure that the trustee is following the dictates that are stated in that trust deed. And so privacy is ensured. There are no religious or customary restrictions. But again, for most things that have their pros, it does, having the trust also have its cons. So it's important that we do this so that you can weigh your options. What we are basically doing here is for you to have, not just have some basic knowledge, but be informed as to the choices that you can make. So one of the, probably the big con to having a trust is legal transfer of assets. So most people, especially in this part of the world, they are not too comfortable with the fact that their asset will be transferred to the trustee. But what should be noted here is that once a trust, always a trust. It means that the trustee has a responsibility under law, under equity, that the trust asset be utilized only for the purpose in which it is created. So even if you transfer your asset to the trustee, it doesn't mean that the trustee is the owner. So as a matter of fact, this duty on the trustee does not even need to be written down. It is an implied duty. So you have nothing to worry about. But we understand that it's probably one of those issues that agitate people's mind. That, oh, why would I transfer my asset to a trustee? And even when you are gone, our trust deed, we always give you the option to appoint a protector. That is, the protector is someone who would have oversight function over the activities of the trustee to ensure that the trust relationship is managed as you intended it to be while you were alive. And in some instances, it may be expensive to execute depending on the asset. So because having a trust entails you transferring your assets to the trustee. So if you are transferring real estate, for example, because of the requirement that every transfer of a legal interest in land must be consented to by the governor, so it may attract that fee. So for small estate, the cost may outweigh its benefits. The cost here could be probably the fees you pay to the trustee and all of that. But again, one also important thing that we've done, especially being in this industry for quite a while, is that we are flexible with our pricing and all. So one thing you should understand is that no matter what your estate is, whether it's a large estate or a small estate, you have a home here at Meristem Trustees Limited, and we can provide bespoke services that would match your pocket. And so when you look at it typically, like I've mentioned, yes, your estate plan, the most important ones are having a trust and a will. But for you to have a robust estate plan, we advise that, yes, you can support your will or your trust with other options. So you can, if you have a trust, for example, you can also think of having what is called the pour over will. So it's possible that when you were creating that trust, you had not acquired some assets, or you have some assets that you do not want to transfer into the trust while you are alive. So you can have a will that then states that those assets should be poured into the trust while you are no more. So that's the option of the pour over will. Or you can then create a trust in your will, which I had mentioned, which is called the testamentary trust. And you can have a fund nomination, which we call a nomination fund, where you make a directive that funds should be made available to a particular person. And this is important because after your demise, before probate is gotten, your beneficiaries do not have access to your estate. And so oftentimes you find out that people are plunged into penury. There's a whole lot of back and forth because they cannot access the asset or funds of their deceased loved ones. So having a nominated fund may help in that regard. And so talking about your trust, like we mentioned, you have nothing to worry about when you create a trust. Number one is the fact that the asset you've transferred to the trustee is not the trustee's property in that sense of the word. It is for a particular purpose, for a particular object, the object of the trust. So if you stated your object of trust to be education or payment of annual sum, that's what it's going to be. You can appoint a successor trustee in case your trustee cannot perform its function anymore. And there's bankruptcy protection for an organization like ours. So you have nothing to worry about that. Oh, what if they go bankrupt and all of that? So there is nothing for you to worry about. And so having understood this, it's then important to ask what next. Like we mentioned, if there is anything that 2020 showed us, and even up till now, is the fact that our mortality stares at us in the eyes. And even beyond that is the fact that you need to leave an enduring legacy for your loved ones. And leaving a legacy is beyond just providing for their needs. It's also important that someone carries your good work while you are away. And so probably one thing I should have mentioned here is that, okay, what type of asset can you even put on that trust? So you can put anything on that trust, whatever your legacy entails. So if you are the type that says, oh, I do not have the fleet of cars, I do not have the big houses, but there is something you have. It could be your artwork, it could be your music catalog, it could be anything that you are well known for. You can provide for all of these using the tools at our disposal at Meristem Trustees Limited. And I hope that at the end of this webinar, you will take that step to preserving your estate. Thank you very much.
All right, thank you very much, Dolapo, for the insightful presentation. It is very good to know that the fact that an individual has a will does not mean that it cannot be challenged, because most people think that all they have to do is just write a will and that is that. It's also beautiful to know that when you trust your assets into the hands of a trustee, it is definitely safe because there is bankruptcy protection for trustees. There is an independent appointment of protectors as well as successor trustees. So you are definitely covered on every end. Thank you very much, Dolapo. It's a pleasure to have you. Okay, for our attendees, if you have questions, please type them in the Q&A chat box. The panelists will attend to your questions shortly. All right, but we will start with the first question asked by Tayo. Tayo is asking, so what are the demerits of a will? Dolapo and Felicia, who wants to take the question?
All right, what are the demerits, right? The disadvantages of having a will? Yes. I already stated some of those, especially the fact that you have to go through the process of probate. So between the time, between the demise of the testator and when probate is granted, your assets are more or less entrusted with the government. So you need to go through that process. And that is, so you have to go through that process. And that is what is not obtainable when you have the trust. So as soon as you are gone, your trust still functions as it is. And then there's also the issue of payment of estate tax, which is 10% of the totality of your estate. That's another challenge. And also that's another disadvantage. And also the fact that the content of your will may be available to members of the public. So privacy is not, may not really be, so privacy is not really guaranteed when you're having, unlike when you have a trust, which is a confidential relationship between the civil law and the trustee. Thank you.
All right, thank you very much, Dolapo. That is very clear. Then the next question from an attendee, Mr. Abel, he's asking, having highlighted the demerits of a will, what would help a client or an investor to choose between a will and a trust?
I'll take that question. Can you hear me loud and clear? Okay.
Yes, I can hear you.
Great. I'll take that question. Now, the choice between a will and a trust, I mentioned earlier that you have to, we as Meristem trustees use our expertise. We'll use expertise to help you, advise you on what to choose. Now, that is based on the circumstance of the individual, the asset class of the individual, and also the family setting of the individual. Those factors are what we look at in advising on what best suits every individual. I mentioned in the introduction that what is suitable for Mr. A might not fit Mr. B, because these factors differ from person to person. So we are available to use the expertise to advise you. You can definitely reach out to us and we'll advise you based on your circumstances, your asset classes, and also your family settings. Those are the factors we consider when advising what method to use in estate planning.
All right, thank you very much, Felicia. It is beautiful to know that, if you do not know which option to go with, come to us at Meristem Trustees Limited. Would help you to decide which option works best for you, be it a will or a trust. That is beautiful. Thank you very much, Felicia. Thank you. All right, Mr. Shedrack is asking. Okay. From the Q&A chat box, can an executor also be a beneficiary? Mr. Shedrack is asking this question. Can an executor also be a beneficiary? Dolapo, do you want to speak to that?
Yes, straight answer, yes.
Okay, why? Can you throw more light, please?
He's an executor. As a matter of fact, if there is anyone who should be a beneficiary, I think the executor should. Because I mentioned in my presentation that probably after writing the will, the most important duty or the most important part of a will is appointing an executor. And the executor is more or less the driver of your estate after you are gone. A whole lot of responsibilities are on them. So, but let me quickly mention this. So one other person or one other party in the will-making process who cannot take benefit under the will is the witness. So when you are writing the will, after you've written your will, you have the testator who signs, and then you have witnesses, those who witness the signature, and they sign to that the witnesses person's signature. So those people generally, they cannot take benefit under that will, although there are exceptions, but we'll not go into those exceptions, but generally they can't take it. So we advise our clients that when you are choosing your witness, make sure that they are not those you intend to benefit under that will. But for an executor can benefit under the will.
All right, thank you very much, Dolapo. It is clearly understood. Ada is asking as a follow-up, what if the investor in this case or the owner of the asset decides to use his lawyer as an executor of his will and the lawyer is not a beneficiary? What happens? Is that okay?
Okay, I'll go ahead and answer that. Now, using a lawyer as an executor, an individual person, when Dolapo was giving his presentation, he mentioned that one of the services Meristem Trustees Limited offers is provision of executorship services. Now, we offer that because the company is a separate legal entity and it exists in perpetuity, means forever, as opposed to an individual, where an individual, upon the demise of the person, of the executor, if he dies before the testator dies, then they still has to look for another person to replace the executor. Whereas if he, on the other hand, if he dies before the will has gone through probate, that might also cost, the state then has to appoint an executor. So that's why we always advise, you can definitely use an individual, but it's advisable for you to use an institution. As Dolapo had mentioned during his presentation, there are different levels of protection for you when you use an institution as an executor as opposed to an individual. I hope that answers the question.
Yes.
Let me quickly add, Ifunanya, that as much as possible, try to avoid using your lawyer as your executor, because I'm aware that there's even a case where a lawyer was chastised for doing that, and people can check out that case. Is NB versus Koku. So although there have been arguments about that, but so that you will not be the person will be reading about in our law report. So please just avoid that. Yes, because there is a case on that where the lawyer was an executor and trustee, and the court was able to say that there was issue of conflict of interest and all of that, especially if the lawyer was the one who drafted, and there has been a lot of relation, and also if the lawyer is probably the lawyer to the estate. So just avoid it. Just avoid it. Yes, you can choose other people as your executors. Thank you.
All right. Thank you very much, Felicia and Dolapo, for that. So to ensure certainty and to ensure that your executor lives longer than you yourself who is writing the will, go for a trustee, and especially Meristem Trustees Limited, because we will give you the desired service and exceed your expectation. All right. Mr. Sheun is asking, can I give some assets to my stepchildren under my will? Can I give some assets to my stepchildren under my will? Okay,
I would like to answer that. One of the good things about writing a will is that you have the ability, testamentary rights, to give your assets to any person you so desire. There are no limits, legal limits to who you give your assets to. As long as the will is written in accordance with the law, you are good to go. So yes, you can. The answer to that question is yes, you can give your assets, whatever degree or whatever amount of assets you have, to your stepchildren and to any other person you so desire. There's nothing stopping you from doing that.
All right. Thank you very much, Felicia. That is pretty much straightforward. Okay. Another attendee is asking, what happens if I die before I sign my will? What happens if I die before I sign my will? Dolapo.
All right. So simple answer again. That's more or less you not having a will, because one of the formal requirements, and I did not just say requirement, but formal requirement of a will is that such a will has to be signed or executed. And as well, not just the law does not even stop at that. The law even says that you should have witnesses who will witness the signing of that will. So it's more or less you do not have a will, and such a will would then fall into intestacy, where your the list of people stated by law can then apply for what is called letter of administration to be able to administer that estate. Thank you.
All right, thank you very much, Dolapo. Emmanuel is asking us another question. Emmanuel says, what happens if the institution one uses as an executor or a trustee goes under? What happens if the institution one uses as an executor or trustee goes under?
Okay, let me take that. Emmanuel, one of the good things about using an institution, like I said earlier, institutions are separate legal entities, right? So they are different from the individuals that run it. So they have there are protections that Securities and Exchange Commission has put into place, whereby if a trustee is going, it can be what they call a successor trustee, meaning that whatever assets or whatever role the bankrupt or the I forgot the legal terminology now, the institution going on, trust company going under, another trust can take it over automatically. So those liabilities just pass from one trust house to the next, and then that is put in place so that the individuals, the corporations, whoever is working with that trustee never suffers that gap. So that's the whole idea. So the Securities and Exchange Commission has put different steps into place, whereby if a trustee goes under, the liabilities and the assets pass on to the Securities and Exchange Commission, and then it is given to other trust houses, existing trust houses, to cater for those individuals and those assets as at when due and as needed. So you just literally transfers it. But as the governing body is the important part here, which is the Securities and Exchange Commission, and they oversee all the trust houses, all players in the financial industry institution. And one of the things they do is because they understand the delicacy and the sensitivity of what trustees do. So they always make sure that stopgap is there. Making one trustee is going now and moving the assets to someone else who can take off the job and make sure there's no gap. The clients don't suffer any disadvantage for that period.
All right, thank you very much, Felicia. In that case, there is a backup guarantee behind every trustee, because if the trustee is not there, the assets are simply moved to another trustee that replaces the initial one. Beautiful answer. Thank you very much. Otheremu is asking us in the Q&A chat box, one of the demerits of a will, as stated in the presentation, is the 10% tax, and nothing was mentioned as regards a trust. Is a trust tax-free? If it is not, how much tax is paid on a trust? Okay, Dolapo, would you like to take that question?
All right, thank you. So for a will, what we've mentioned is the estate tax, that is the tax that is applicable after the demise of the testator when his beneficiaries are trying to get that asset. Now for a trust, what is taxed? So the income that gets to the hand of the beneficiaries can be taxed. Yes, because incomes are taxed in Nigeria under our various tax laws. So the issue of estate tax does not apply in a trust relationship. What you are looking at is oftentimes income tax, the income that either the trustee generates on the management of that asset, or that is paid to the beneficiaries who are stated under the trust. Yes, so that is it. So there's a distinction between the estate tax and income tax. So income tax would arise in a trust relationship where benefits are derived under that trust, while estate tax is what is paid at the demise of the testator when you are trying to gather the assets. Thank you.
All right, thank you very much, Dolapo. Okay, we have another question from Mrs. A here. Mrs. A is asking, can I just have my spouse be a joint signatory to my bank accounts? Can I just have my spouse be a signatory to my bank accounts? Does that suffice?
Okay, I'll take that question. Being a signatory or a joint signatory does not legally, how would I put this? Okay, being a signatory to the account does not mean that you have transferred your interest to that account. If it's only the monies you're worried about, once the partner, if Mr. A and Mr. B are joint signatories to an account, once and signatory mandate is either or, right? So you're saying, oh, the person can just take out the money. Yes, but legally, that Mr. A that died owns half of that money because it's joint. So he has an estate, he has an interest in that. So if someone wants to take you up on it, the person can. They're like, you've taken something that doesn't belong to you. That's why for that fund, even if the person is your spouse, it doesn't delete automatically to you. You still have to go, if the person hasn't written a will or put in any other estate planning tool, any estate planning mechanism, you have to go and obtain letters of administration to get access, legal access to that fund. So putting someone as signatory does not help or does not cure. Yes, does not cure that gap, because the person hasn't transferred their interest in that fund there to you. So if you take it, you can have access because the bank might not be aware. But once the bank comes aware, there might be an issue there. But once pending that time, the right thing to do, the legal thing to do, is to get probate if there was a will, or to get letters of administration to be able to access that fund. More so, your assets might not just be cash in bank. You may have other things. So what if they take cash in bank? What about the other things? So it's better to just tidy up your house, tidy up everything, make sure everything is in place, so that more upon demise, the person can just obtain probate if you did if you wrote a will, and then get full and legal, unconsequential access to the funds and other assets that the spouse owns.
All right, thank you very much, Felicia. There's another question from Mr. Victor, who is saying, how can I remove my son from my will? How can I remove my son from my will?
Hello?
Yes,
Hello.
we can hear you.
All right. So a will, there's a term they use to say a will is ambulatory. That is, it only becomes effective after your demise. So more or less, it floats as you are alive. So you can use what is called a codicil. That's a means of amending your will or revoking your will. So yes, through the process of codicil, you can remove a beneficiary, you can add beneficiaries, you can add assets, you can do a lot of things. So the codicil is one way you can amend your will. So whoever wants to remove a beneficiary or add another beneficiary, what they need is a codicil to that will, which is more or less like a will. Yes.
All right, thank you very much, Dolapo. Mr. Manuel is saying in the chat, I beg to differ on joint signatory issue. Felicia, would you like to speak further to this?
No, let me just come in. Let me come into that, so it won't be like Felicia. Yeah. So the issue of joint signatory is like we have a big house that has maybe 10 rooms. I have 5 rooms. Maybe my brother also has 5 rooms, and we all have the keys to that apartment. So which means if I'm not around, he can just open the apartment and go in. So that's more or less what being a joint signatory means. So you see, that is why we advise that before you write a will or before you take a decision, it's important for you to consult experts. So, and I'll quickly try to explain this. There is something called joint ownership, or tenancy in common, or ownership that you hold in common. So for example, if you jointly own an asset with someone, and it does not mean that monies in the bank are jointly owned. The fact that you have a co-signatory does not mean that it's jointly owned by both of you. You understand? It could be that person A has a certain percentage of that fund, person B has a certain percentage of that fund, while they are just both signatories to it. So people conflate that oh, because we are joint signatories, it means that whatever is there is jointly owned by us or equally owned by us. So back to what I was explaining. So where an asset is jointly owned, that is, there is no severance that, okay, 50% is for this, 50% for the other, or 60% is this, or 40% of this. At the demise of one of those owners, the asset is called the rule of survivorship. It survives the demise of that person and becomes that of the surviving person. It's called the rule of survivorship. But where it is owned in common, say I have 60% of what is in there, you have 40%, I have out of 1 million, I'm the owner of 300, you are whatever. In that case, after my demise, whatever is mine should go to my beneficiary. It does not become yours. So like I said, the fact you are a joint signatory to an account is like having common keys to a big apartment. And we know that the fact that you have a key to an apartment or to my house does not mean that after my demise it is yours. You only have a key, you understand? So it's important for us to understand that. And that is why when people come to us and they say that, oh, I have an asset with my spouse, we like to ask, is it jointly owned with your spouse? Or what is the nature of that ownership you claim you have with your spouse, so that we know how to advise. Thank you.
All right, thank you very much, Dolapo. Thank you very much for the detailed answer. Okay, another attendee, Mr. Sahid, is asking, does that mean with regards to the question of removing a client or an investor's son from his will, he's asking as a follow-up question, does that mean that you can disinherit a beneficiary from a will? Does that mean that you can disinherit a beneficiary from a will?
Yes,
and
you have that.
Okay, sorry, one more line. Okay. Would that be of any cost to the investor? Thank you.
So you have that testamentary freedom, yes, to make whoever your beneficiary and all of that. And so that freedom also entails, also extends to removing a beneficiary from your will. And in terms of cost, maybe the cost is the fee you pay to write your codicil and lodge it at the registry. So you have that freedom. However, let me also mention that most will laws provide for what is called reasonable provision for dependents. So if your child is your dependent, and looking at the circumstance, reasonable circumstance, this person is your dependent. So let's make this real. So you have a 10-year-old son who is in probably GSS2, and then you remove them from your will. And after your demise, there's nothing for such a dependent. Such a dependent can apply that out of your asset, provision should be made for such dependent. That is what is called reasonable provision for dependents. So yes, you have removed that person from the will, but the lostee expects that reasonable provision be made for that person. So the answer is yes, you can remove whoever you want to remove, you can add whoever you want to add, but if that person is your dependent and looking at the circumstance, they can't fend for themselves, then a portion of that asset will be used for their upkeep. Thank you.
Okay, quickly, I would do our best to answer all the questions in the Q&A chat box before we round up for today. So Adetola is asking, how do I get letters of administration for my shares? How do I get letters of administration for my shares from Adetola?
Okay. All right.
Okay, go ahead, Dola.
Okay, thank you. So having letter of administration connotes that there is no will or an invalid will, or there is no executor, depending on the circumstance. And so you will need to apply to the probate registry to get letter of administration. And you also need to check. So you need to consult, say with Meristem trustees, to know if you have, so the person said that letter of administration for my shares. So, I mean, it's not even, I shouldn't even answer that, because number one, it's not your shares, because it means you are deceased. So maybe you mean the shares of your deceased parent or anything. So I would take it as that shares of your deceased parent, yes. So you need to check. So if it's for your deceased parent, yes, you can apply because you are one of those who are eligible to apply. But if the person is just somebody who is your loved one, you guys were really close, you are bestie, and the person said that, oh, after I die, everything is yours. It may not be so. So you need to check, number one, the list. Are you part of those who can even apply for letter of administration? And the fact that you can apply for letter of administration does not mean you can benefit. So that's one thing most people confuse. So somebody has died without leaving a will. So they know that there is a list of people who can apply for letter of administration under the administration of estate law. People then assume that those people who can apply for letter of administration are also those who can benefit from the estate. Not all of them. So depending on the type of marriage you had while alive, depending on the cost that applies, these are the things that will determine who will benefit. Yes, so it is not a straightforward answer. So also the issue of shares, if they are the shares of your parents and maybe both parents are deceased, sure, you may apply for letter of administration and they can become yours. If either the father or mom is still alive, you need to check if under the law it will not go to such a person. So it's a whole lot of consultation to be made. It's not just a straightforward thing. Thank you.
All right, thank you very much, Dola. But it's very important for our attendees to know that the fact that you can apply for a letter of administration doesn't mean you can benefit from the assets of the deceased. To know more, please fill out the questionnaire in our chat box. It is right there. Please fill it out to enable us to contact you and discuss more about the assets of your loved one who is passed and how you can recover them. Okay, Oteremu is asking very quickly, how does Meristem ensure that there are no legal issues as regards the assets put under trust, especially for politically exposed persons? This is in our Q&A chat box. We have seen cases where beneficiaries of trusts have been denied access to those assets at the demise of the owners. Can we answer this one quickly?
Okay, I'll take that question. Okay, the specific nature of this question is based on politically exposed people. During Dolapo's presentation, he mentioned that trust, one of the good things about trust is that you can determine, one of the good things that you can determine who, while you're alive, you can see, if you create a living trust, you can see who your beneficiaries are, right? And who your assets are going to and how it's being devolved right now while you're still alive. So yes, creation of a trust, as he also mentioned, does not mean that you're giving the trustee your assets. The nature of trust, as the name implies, is that a person is holding it, Meristem Trustees in this instance, is holding it in trust for you and the beneficiaries you have indicated. One of the single most common and important documents in such a structure is a trust deed. The trust deed is what guides and states exactly the relationship between the trustees and the settlor being whoever creates the trust. Now, irrespective of whether the person is politically exposed or otherwise, the trustee is bound by the provisions of that trust deed. So I don't know what experience you've had as to your question, as to your comment on beneficiary not having access to the trust. But once a trustee puts it in place and states that I want so and so to happen, either, as Dolapo explained, there are different types, a living trust or a testamentary trust or whatever other type of trust you create. The trustee is bound. There's a fiduciary relationship already created. The trustee is bound to honor those provisions. Now, when trust houses or trustees are dealing with politically exposed people, they have to inform the Securities and Exchange Commission. It's a compliance requirement. That is what is expected from us. Apart from that, there's no difference between a particular exposed person and other people. Just that we do have to write to the Securities and Exchange Commission, notifying them that we are dealing with such a person and details of what transaction we are going on. So there is no way a trustee, the legal framework does not provide for a trustee to take over assets, because as Dolapo said, we are keeping it in trust. We are but a warehousing, an operational warehousing protector. Yes, that's for the benefit of third parties, as indicated by the settlor. I hope that answers your question.
All right, thank you very much, Felicia. That is well answered. The last question for this webinar from Adetola is, can you decide the fate of a property owned by you and your wife? Can you decide the fate of a property owned by you and your wife? It would be nice if we answer this question when there is a will and when there isn't, and also when there's a trust and when there isn't. Thank you. This is the last question for today. Thank you.
All right. So I think I mentioned this briefly in my explanation. So if it's a property that is jointly owned by two people, jointly owned property, you can't just make that decision for your wife, you understand? So because like I mentioned, there is what is called the rule of survivorship in property that is jointly owned, which means that after your demise, it transfers to the next person, the surviving person. This is the rule of survivorship. But if it's a property that is owned in common, that is, say, for example, you have a 4-bedroom apartment, and you know that, oh, 2 bedrooms are mine in this house, 2 bedroom, the other 2 bedroom is for my wife. You can choose, you can do whatever you like with the 2 bedrooms that are yours. But where that property is jointly owned by both of you, joint ownership, you cannot make a decision without consulting the other person, because after your demise, by the rule of survivorship, the next surviving person takes over it. So it means that if you make a decision without them, you are taking away their rights under the law. So you can't do that. So you need to consult with your spouse where there is the issue of joint ownership of property.
All right, thank you very much, Dolapo. We have come to the end of this webinar, but before we leave, we would like to leave our lovely attendees with a few words from Meristem Trustees. Felicia, I'll call on you shortly, but please go to the chat box to all our attendees and fill out the questionnaire in order to enable us reach you after this webinar to discuss further. Okay, back to you, Felicia. What are the last words we have for our attendees?
Thank you very much once again, everyone, for attending. I would like to reiterate that ownership, as Dolapo, I think I should leave that to Dolapo, but joint ownership is different from, as Dolapo is different from owning something jointly, as in having things together in a single purse. So I just want everybody to note that even if you build a house, for instance, and it's owned by yourself and your wife, we have to take the cognizance that that does not automatically belong to only you. You have done it together, and the law recognizes both of you as having equal interest in that asset. So I just want to make sure everyone understands that point. Thank you all once again for joining, taking our time this evening. We really appreciate it, and we look forward to serving you in our capacity as Meristem trustees in writing your wills, in drafting up your trust documents, in estate planning generally. We look forward to being of service to you. Thank you once again, and do have a lovely evening.
All right, thank you, Felicia. Thank you very much, everyone, for attending. And we hope to hear from you as you have filled the questionnaires. Have a lovely evening. Goodbye.
You've reached the stars, now let's see you conquer galaxies. You've gone for gold, let's show you 2 more treasure chests.
Your story doesn't have to end with you. As a matter of fact, it can continue into the next generation.
The only way to move is up, the way to go.
And the generation after that.
Don't stop.
After all, you've worked hard to get to where you are. Why should your wealth end with you? Let your story continue.
Meristem, let's grow wealth for you.